definitely. The payment changes are huge. And what we're trying to do in this section is basically give you an introduction to the things that you will see going forward. There is no way in a short workshop of around 40-45 minutes that we can possibly cover all the potential scenarios. However, we are going to aim to make sure that you are given a very good introduction to these changes. I'm going to start off with actually explaining some new terminology. We've got three new terms that no doubt anybody who's involved in payments, whether they're making payments or receiving payments, these words will soon be tripping off your tongues. The first one, the payer. The payer is the party who makes the payment. This is a little like the employer who pays wages to an employee. So in other words, the payer pays money out. The second piece of new terminology is the payee. So in other words, the party receiving the payment, a little bit like an employee who receives wages. So payer pays money out, payee receives the money. We then have the third new piece of termination, which is the specified person. Now the specified person could be the architect, contract administrator, employer's representative, or indeed if you're on an NEC style contract, this could be the project manager. So throughout the next section, keep remembering payer makes payment, payee receives the payment, and a specified person basically is the person who's responsible for administering the contract. So let's have a quick look then at change number 1. If I go back in time 15 years ago, before the Construction Act 1996, the fashion back then was for pay when paid, and there are hundreds of articles written about payment abuses and subcontractors under our pay when paid provision. I'm sure you're aware that this was actually outlawed under the Construction Act 1996, and I've quoted it on the slide in front of you, section 110.1, which stated, every construction contract shall provide an adequate mechanism for determining what payments become due under the contract and when. The fashion then for cash-conscious main contractors turned to all intents and purposes, a circumvention of the Act. In other words, pay what certified or pay when certified. There was certainly a lot of debate in case law on whether those clauses were actually enforceable or not. They relied, main contractors, on such clauses to ensure that they did not have to pay a subcontractor until they had at least received a payment certificate under the main contract. You can see on the slide in front of you, under LDEDC 2009, the Construction Act 2009, some words in red. Let's just look at those for a minute. The requirement is not satisfied where a construction contract makes payment conditional on the performance of obligations under another contract, or a decision by any person as to whether obligations under another contract have been performed. So in other words, this is an attempt by this new piece of legislation, the Construction Act 2009, to actually snip the link and to prevent pay what's certified or pay when certified. An example final payment provision under a subcontract is on slide 19. And this states, in our example, clause 11.9, the final payment shall be due not later than 14 days after the issue of the final certificate or its equivalent under the main contract. This clause is no longer enforceable. And the same is true of the next clause down. 11.10 states, the final date for payment of the final payment shall be 35 days after the date that it becomes due, or receipt by the contractor of the subcontractor's VAT invoice in the amount of the final payment, whichever is the later. Indeed, if you see such clauses in contracts going forward, then those clauses would be crossed out and the scheme would apply, the scheme for construction contracts. And the scheme says that the final payment monies are then due 30 days after completion, and under Clause 8 they must be paid 17 days later. So main contractors obviously want to hold on to subcontractors' retention monies for at least a year, and longer if they haven't had the retention released themselves. But under the scheme, they'd actually have to be paid in full 47 days after completion of the works. I've put there on the slide, how do you think payers then may try to circumvent these new provisions? Well, obviously, a pretty easy way would simply be to say the final payment, including release of retention, shall be due 52 weeks after the subcontractor has finished work on site. But that probably wouldn't be enough for main contractors who want to hold on to, say, ground workers' retention. And so they may be looking at periods for release of retention of 18 months upwards to try and circumvent these new provisions. I'm sure, again, there'll be some interesting case law on this particular issue. As far as I'm concerned, the big change comes in Section 110 or Section 143 under the Construction Act 2009. This is a huge change. And I will say that I think we're probably in a bit of a comfort zone in being familiar with the existing provisions. Again, please be aware this is only an overview, and a more in-depth review is vital if you are to be ready for the 1st of October 2011. On the slide in front of you now, you can see the Construction Act 1996 payment provisions. Usually, the way most construction contracts work at the moment is we have an agreed interval or stage, and that's normally monthly. So in other words, every month the main contractor or the subcontractor will put in an application for payment. The due date is normally the last working day of the month, although in many contracts you would see the due date being 1 month after you start on site. But for the examples that I'm going to go through today, work on the due date being the last working day of the month. You can then see in capitals the words agreed period. This could be, if you're lucky, 14 days, 30 days, and if you're less lucky, 60 days, 90 days, or even longer than that. So X number of days after the due date, we then hit the final date for payment. Below that, you'll see that I've actually just brought up 2 bubbles below the purple line. And the bubbles refer to a notice of payment and a notice of withholding payment. Dealing with the one on the left first, the notice of payment. There was great hopes for this notice when the Construction Act 1996 came in. The piece of legislation clearly said that a notice of payment had to be served 5 days after the due date. Unfortunately, in the case law that occurred after the 1st of May 1998 under the Construction Act 1996, the courts decided, well, actually, don't worry too much if a notice of payment is served. What the parties have to do is look at the facts of what has actually been done on site. You have to prove what was due for payment. And if you can't prove what was due for payment, well, to be honest, the notice of payment isn't important. And indeed, this notice of payment was actually described as a technical breach only. So it sounded as if this notice of payment would have huge teeth and would really help the parties receiving payment with their cash flow. Unfortunately, that wasn't the case. However, we did have this issue of notice of withholding payment. And if a party wanted to withhold some monies, normally for liquidated damages, provision of hard hats, safety boots or cleaning up charges, a notice of withholding did have to be issued. The agreed period that you can see there under the purple line, well, actually most main contractors made that period 1 day before the final date for payment. And this notice of withholding was actually used in the industry when there were problems with the work that the subcontractor was doing, which may have had to be knocked down, or indeed when a subcontractor or main contractor was completing late. So a notice of withholding payment was only used for set-offs, contra charges and counterclaims. It wasn't needed to be used if there was a challenge to monies due. Let's move on and look at the new regime. And the new regime is different. In fact, it's enormously different. Starting off with the first bullet point. Under the Construction Act 2009, the new piece of legislation, it states there the payment notice must be served within 5 days from the due date. Just think about that for a minute. What does 5 days, first of all, actually mean? Let's say the due date is a Thursday. Count 5 days from the Thursday, remembering you have to include weekends. Friday, Saturday, Sunday, Monday, Tuesday. The payment notice must reach the payee, the person receiving payment, by the Tuesday. That's an extraordinarily short period of time. It's vitally important that the payer makes sure that in every single case the payment notice is issued, even if the amount to be paid is nil. The second bullet point there says the payment notice may now be given by the payer, a specified person, or by the payee. The specified person on the payee bit is definitely new. The specified person, as we talked earlier, relates to the architect, contract administrator, project manager. The payee is the person receiving the payment. And whilst it sounds a little bit bizarre that the payee can actually receive the monies and actually issue his own notice, that's what the piece of legislation actually says. And whoever serves this payment notice, whether it's payer, payee, or the specified person, they must specify the sum due and, importantly, the basis on which that sum is calculated. Just think about that. I've put there on the notes, there may be trouble ahead, because actually we've not given any guidance at all as to how much detail is needed. What I can say with certainty is that, say, 20 grand on account would not be sufficient detail. And certainly my advice to anyone issuing the payment notice would be give as much detail as possible, because you don't want to find that your payment notice fails for lack of detail. Importantly, the application for payment from the payee may actually be the payment notice, and we'll look at that for in a minute. But even the application for payment, if it's to be of significance and of standing, that must comply with the requirements for the valid payment notice in terms of detail. Let's look at this graphically.